Good evening. Um, Allow me at the outset to thank the International Academy of Space Law for this opportunity to share some of my experiences working with space technology businesses, and especially in the context of helping them navigate through the complex world of space laws. So, before we begin, I would like to just quickly take the audience through the various you know topics that we will be covering under this presentation. So let us quickly jump into the first slide. Okay. Now, I'm sure all of you have already had a fair amount of exposure in this course as to the various international legal regimes that are applicable to space activities. So in this presentation, however, I'm shifting the focus to how space laws will apply to a space business. Now, for a space business, space law does not necessarily have to do as much with issues around militarization and weaponization as much as it has to do with getting licenses to do business involving space, getting clearances from the government for either launching satellites, developing applications based on space technology, things like that. So in the context of a space business, space law can be very different compared to the conventional understanding of space law. Now, going slightly into the next element of this presentation, which is dwelling into some of the more practical nuances of space law, I will be covering about 2 or 3 slides to launch services agreements. Through the help of case laws and case studies, we will also try and understand what needs to be addressed in a launch services agreement and what are some of the implications of leaving open-ended gaps in a launch services agreement. Thirdly, we will also be looking at some of the interplay between international trade and investment law and space law. And last but not the least, I will be focusing very briefly on some of the remote sensing commercial applications that are being developed from the point of view specifically of privacy regulations. So what does space law mean for a space business? So let us first understand what is the space business. For the purposes of this discussion, I'm classifying all space businesses into upstream and downstream. So the upstream space businesses will essentially deal with all those technologies and businesses that are intended to take either people or objects or payloads from Earth and put it into space. And as far as downstream space activities are concerned, we will be dealing with all the dividends that people on Earth derive from technology in space and the business model involved in it. Now, for both upstream and downstream space businesses, when we discuss space law in the context of this presentation, what we will be referring to is what are the non-space law related rules and regulations which are applicable to a space business, very briefly again, and B, what are the space laws which affect commercial space activities. So based on this, what are how do these non-space and space related legislations manifest themselves in reality? So we look at all the rules and regulations that comes under this definition of space law into 3 categories. We're looking at international, national, and contractual. So under the international rules and regulations, we broadly see standards of behavior, which is your outer space treaty. We deal with certain international legal instruments addressing the question of liability. We are dealing with international legal instruments of registration of space objects, which prohibit militarization of space, which prohibit exclusive appropriation of space. So that is at an international level. And the primary objective of these international rules and regulations is to regulate the conduct of states. Now, in order to address the application of international law and the enforcement of international law, what the states do is that based on the international legal instruments that they have agreed upon or adhered to, they also translate those international legal obligations into domestic rules and regulations. These domestic rules and regulations are in the form of either legislation or regulations, guidelines, and rules and policies. Last but not the least, the one of the other sources of space law is also the concept of contracts. So to give you the most simple example, a licensing contract for the use of spectrum is the most typical example of a contract-based space law that emerges. So let us jump into the very first subject under this presentation, which is all the issues and considerations that emerge in the context of launch services agreement. So a typical launch service agreement essentially can be divided into two categories. So our launch service agreement addresses the general legal requirements of contract law, of insurance and indemnity, intellectual property rights, and more specifically related to governing law and jurisdiction. From the space law perspective, a launch services contract must address concerns around space situational awareness. In the process of addressing space situational awareness, the contract must make a balance between the expectation of trade secret rights of payload owners versus the requirements of international law related to transparency, non-weaponization, etc. Two, the launch services agreement must also adequately consider and reflect some of the rules and regulations formulated by the International Telecommunication Union. So if you have gone through the international telecommunication regulations, especially for placement of orbits of satellites into orbit, what you will notice is that there is an elaborate mechanism by which states are reserving what orbits are available to them, a notification procedure to notify the ITU as to which person or which satellite will sit in that orbit, and the intended objective of the payload being in that particular orbit space in the first place. So in order to ensure that there is no effort at suppression of facts, there's no effort at a satellite that does not have adequate clearances going up into space, the ITU regulation acts as a transparency platform. Now, the third issue, the related third issue is, of course, this concept of statutory compliance. So essentially, especially when we are looking at a cross-border launch services agreement, payload owner in country A contracting with a launch service provider in country B, there could be a variety of domestic legal requirements that needs to be satisfied. So the question of who is to address what aspect of statutory compliance is also a function of the launch service agreement. The fourth element, of course, is you would ideally want to use a launch services agreement to give yourself the necessary powers to prevent the violation of treaty obligations, and B, in the event those processes fail, you also want the launch services agreement to clearly identify the point of liability. Now, the next element related to space law that a launch services agreement must cover is the question of inter-party waiver, because the concept of launch of a payload into space is by definition a high-risk activity. So it is a standard practice in the context of launch services agreement for all parties to actually agree that they will assume the risk associated with the launch services, and they will not hold each other accountable for a failed launch. The space law, the specific element of space law that launch services agreement must also address is insurance, because in the event of a damage arising out of a launch, especially to other space objects or to people on the ground, there are very specific liabilities stipulated under the liability convention. So in that scenario, having an adequate insurance provision incorporated into the launch services agreement ensures that not only are you allotting risk as per with sufficient clarity, but the person who is ultimately responsible also has the means to satisfy the liability. You also, of course, want to address the question of registration. Non-registration of satellites results in breeding international insecurity. It could potentially contribute to conflict and misunderstanding. It makes traceability difficult in the event of damage. So having a clear mechanism for registration is very important, which the international law already stipulates, but ensuring that the contract not only prescribes very clearly who has to register the satellite, but also the corresponding consequences that follow in the event of non-registration, ensures that there is no question mark as to whether the launch service provider and the country that he belongs to is considered as the launching state or not. So on going back to the general legal implications again, the launch services agreement must of course address the payment terms and issues of especially specific to sharing of space on the launch vehicle. It's not uncommon that we see multiple payloads being launched by a single launch event. So in that scenario, ensuring that the place on the launch vehicle is adequately and equitably managed is also a function of the launch services agreement. So the right kind of launch services agreement across all the payload owners ensures that there is no ambiguity or confusion between them as to what are the payloads sitting in the launch service vehicle, and what is the amount of space available, the commercial terms and conditions, and to make sure that the payload of one payload owner does not represent a threat to the other payloads. So we broadly understood some of the functions of the launch services agreement. Now let us look at some case studies to understand what happens when the launch services agreement does not have the requisite amount of clarity. So the first case study is of an unidentified flying object that the Federal Communications Commission actually identified. So this was a particular case study where the Federal Communications Commission of the United States government one day suddenly detected signals from space which was not documented as per their records. So there was no approval sought for beaming signals in that particular spectrum, and the signals were undocumented and unprecedented. So when the matter was probed, what they realized was that an American company had contracted with a launch service broker in a different country to launch a constellation of satellites, even though the SATCOM applications were not cleared by the Federal Communication Commission. So essentially, what happened is that the payload owner, the launch service provider, and the launch service broker in between had either knowingly or unknowingly put a satellite into space, even though that satellite was not legally sanctioned by the country of domicile of the payload owner. Now, in a scenario like this, there are multiple questions that arises. We know now that there are rogue satellites in space. Who bears the responsibility for it? Is it the payload owner and therefore the country in which the payload owner is domiciled? Or is it the launch service broker or the country where he is domiciled? Or is it the intermediary in between, or the launch services broker, or the country where he is domiciled? So this question is not readily addressed under international law, because the concept of a launching state is either the state that launches the payload or the state that procures the launch. So technically, in a situation like this, both the launch service vehicle owner and the state is also a launching state, as well as the payload owner's country also qualifies as a launching state. So a contract on the nature of a launch services agreement can effectively address this by putting the onus of domestic compliance on the payload owner or the launch services broker, or if they're willing to assume that responsibility, upon the launch services provider themselves. But at the end of the day, that clarity is needed in the launch services agreement. Now, the other question that arises is what happens to the middleman or the launch service broker in a situation like this? So this again does not have a ready answer under international law. But we can look at certain concepts that have emerged in domestic law to understand what could be the potential liability. So in the context of e-commerce platform providers, the European Court of Justice held in the case involving fashion brand and e-commerce retail service provider, that if the e-commerce provider goes beyond the function of an automated platform provider and takes a more active role in facilitating the sale and the purchase by regulating the price terms, by regulating the bidding terms, then he is no longer exempted from the liability that follows in the event the transaction leads to an illegality. So similarly, it could be argued, again on the basis of the language employed in the launch services agreement, that if the launch service broker has assumed sufficient responsibility of facilitating the transaction all the way from getting export clearances from the country of the payload owner to bringing it into the country of the launch services provider by getting it through customs, he has to some extent played an active role in the transaction. Therefore, his liability could be that of the liability of the e-commerce retail provider when the e-commerce provider actually assumes the role of an active facilitator. So the point of this discussion is to simply state that the launch services agreement must effectively address the question of who is responsible for what. And unless and until that level of clarity is found forthcoming in the launch services agreement, the resulting gray areas can make the question of liability very difficult to answer. So what are the lessons? The first lesson from this case study is that it is no longer a day and age when launch activities is only advancing sovereign functions. It is now addressing even commercial functions as well. So a company like Antrix, which is a private limited company owned by government of India, at one point of time, perhaps it was open for them to argue that they are immune from prosecution by the laws of a foreign country simply because they are a sovereign wing of the Indian government. But today they are also performing non-sovereign functions, so that immunity and that exemption is no longer available. Second, the launch services agreement cannot be employing a lot of the existing templates because they do not address the liability of the broker. And in terms of the allocation of legal risks, the requisite level of clarity may not always be forthcoming in the existing templates. Last but not the least, if the launching state intends to exempt itself from any responsibility by arguing that it is not possible for country B to know the domestic legal requirements of country A, then the ITU notification procedure comes in the way of their defense. For the reason that if the country A was fully okay with the payload owner's activities, they would have notified the ITU, and that notification acts as a transparency platform. So therefore, all the country B had to do was to simply verify the contents of the notifications in ITU platforms. And if the notification exists for the payload, then they know that the payload has domestic clearances. But if there is no notification by country A in respect of that payload, then we know for a fact that country A has not given the domestic legal clearances. So therefore, the launch services agreement cannot just contain a self-declaration from the payload owner that he is compliant with domestic laws. It must also result in a consequential process of verification where the launch service provider can actually verify this claim of the payload owner. So we come to our next case study, which is how do we address the concept of a failed launch? Because a failed launch can result in the destruction of the payload, which is lost technology. The lost technology leads to lost business opportunity, which is potential transponder leasing arrangements that are no longer viable. And if there are back-to-back commitments that the payload owner has made with content distributors for providing broadcasting services, then there is also a potential for litigation. From a public policy point of view, it creates debris, which is again one of the most significant risks to the environment of space. And last but not the least, it results in significant loss of credibility for both the launch service provider as well as the payload owner. So this issue was adjudicated by the courts in the United States of America in this specific judgment, which is Martin Marietta Corporation versus Intelsat 763. That's the citation. So this is a conflict between the launch service provider, which is Martin Marietta Corporation, and the payload owner, which is Intelsat. Now, this was a case where Intelsat's payload was not successfully launched. The mission failed. So Martin Marietta Corporation went to the court asking for a declaratory judgment that they are exempted from any kind of legal liability. On the other hand, Intelsat came back and said that the launch service provider is responsible for the loss. So therefore, liability ought to be fastened on the launch service provider. Now, central to this entire dispute was actually the launch services agreement, which contained a provision related to inter-party waiver. So one of the claims that Martin Marietta Corporation made was that since the Commercial Space Launch Act of the United States specifically recognizes inter-party waivers, the existence of inter-party waivers in the statute essentially means that Intelsat can never prevail in that claim against Martin Marietta Corporation, and therefore the claim must be dismissed outright. However, Intelsat rightly contended, and this was the view that was upheld as well, that the law of the United States, which is the Commercial Space Launch Act, only enabled the parties to introduce an inter-party waiver into the agreement, whereby each person waives any claim that they have against the other for a failed launch, but it does not by itself waive off the liability. So the court ultimately concluded that the law only enables parties to enter into a contract where there are waivers of liabilities, but it is up to the parties to specifically introduce it by way of contract that they will not hold each other accountable in the event of a failed launch. The second point that the court made, which could be very interesting and especially beneficial from the point of view of the importance of a launch services agreement, the Intelsat's claim was based on both contract as well as tort. So they said even if there is a waiver of liability on the contract, under the common law of torts, they still have a claim that is admissible, and the claim was based on a claim of misrepresentation by the launch service provider, and B, on the basis of an allegation that the launch service provider was guilty of negligence. But the court held that the mere entering into the launch services agreement seems to suggest that the dispute can be adjudicated exclusively by the agreement and not by common law of torts. So on that basis, the entire claim of Intelsat on the strength of the law of torts was negated. So the advantage of this judgment is that in the event the launch services arrangement is governed by a specific contract, the unforeseen liabilities under other laws like torts can potentially be avoided by ensuring that the language of the launch services agreement is adequately clear. So the other argument that emerged was that these kind of inter-party waivers are opposed to public policy. So in countries like England, India, and the US, and say even Australia, any contractual clause that is opposed to public policy is not enforceable. So one of the points that emerged during the conversation in this dispute is that the inter-party waiver essentially exempts liability even for negligence and therefore opposed to public policy. But the court cited the Commercial Space Launch Act, which acknowledges and recognizes inter-party waivers to hold that the intent of the legislature is to support inter-party waivers, which itself is testament to the public policy utility that it serves. So on this ground, the contract eventually absolved the launch service provider of any liability. So what are the lessons from this? The statute is only an enabling factor. It creates an atmosphere of freedom of contract, but the exercise of freedom of contract must be diligent enough to introduce waivers of liability and allocation of risks. Waivers in the nature of launch are at least were pro-public policy, but in the day and age of space debris and sustainability questions, it remains to be seen whether inter-party waivers will continue to be interpreted to exempt negligence which results in a failed launch, especially when it causes debris. So we come to the third case study, which is a secret payload case study. Simply put, there was a moon mission. A country in the Middle East had decided to send a payload on the moon mission. The payload was supposed to contain some instruments and some technology, all non-biological material. But once the mission had matured to an advanced degree and the payload was already in space, then the revelation was made that the payload contained what are called as tardigrades, which are microscopic organisms, very resilient, known to survive in space, 900 known species. So they ended up landing in the moon atmosphere. Now, the moon atmosphere, by some schools of thought under space and international law, has a right against contamination. Now, the question is, how do you address a situation like this in a launch services agreement? So there is a planetary protection policy of COSPAR, which does not yet enjoy the status of international law, but it does give some guiding principles as to how the concept of contamination of other space atmospheres have to be addressed. But from the point of view of launch services agreement, you want to make it very clear that as a launch service provider, you will have the right to inspect the payload and verify the claims of the payload owner that it only contains material A and nothing else. You also want to stipulate a procedure for authorization, whereby you know for a fact that the payload has gone through a series of domestic checks and balances before it crosses the border for the launch services vehicle. You place upon the payload owner the duty of full disclosure, and the contract also should place upon the payload owner the duty to notify the launch service provider when the payload design and intended use changes. With these provisions in the launch services contract, the ability to hold the payload owner accountable, notwithstanding inter-party waiver, improves significantly when the payload is stated to be of design A, but it happens to contain design B instead. So this way, what we are also doing is we are trying to ascertain and allocate the risk under the, as far as liability under the Outer Space Treaty is concerned. Who has the duty to authorize and supervise the launch? Who has the authority to exercise control and jurisdiction over the payload and the resulting illegality? And to make sure that due regard is given to the duty not to contaminate the outer space atmosphere. So again, the lessons, self-declaration of payloads is not sufficient. You want a mechanism in the launch services agreement to verify the declarations of the payload and owner. So that way you're also getting the means to discharge the potential duty of care that the law could interpret for the launch service provider. There is allocation of consequential liability. So you make sure that through this procedure, you also verify whether the insurance coverage covers the surreptitious design of the payload. And last but not the least, you also want to look at the larger context of, does public interest towards transparency of the payload outweigh the private interest of trade secret rights? Because at the end of the day, a trade secret right grants a valuable economic benefit, but all said and done, you also need to ensure that the need for transparency to prevent debris, to prevent contamination is equally addressed. So the launch services contract is also a way of trying to address some of these ethical and moral dilemmas. So we'll come to the next element of the presentation, which is international trade and investment law. To summarize, to paraphrase this, this particular slide, we are no longer looking at space just to satisfy an existential curiosity as to who we are in the larger context of the universe. Now it is existential curiosity, military applications, and commercial applications. So there is a huge role of international trade and investment law into SATCOM and related space activities, but they have never truly interacted with each other to kind of bring exchange perspectives. So in an atmosphere of this, there are certain case studies on bilateral investment treaty litigations that could be useful to understand how trade and investment law can impact space activities. So the importance of domestic law is that it brings in a certain level of predictability to the investment. So you know exactly what is the nature of the economy in which you're investing is and how much protection you have and what are the potential benefits or the ease of enforcing the investment contracts that you're going to enjoy. So historically, in the book Sapiens, there is a specific reference to the comparison between the efforts of Spain to colonize and the efforts of the Netherlands to colonize. And one of the reasons why Netherlands was seemingly more successful was the rule of law and the stability towards and the fairness towards foreign investments was much more significant and much more obvious in Netherlands as opposed to Spain. So we know historically a good stable regime of law can potentially either increase investments or decrease investments. So accordingly, states make the effort to attract investments through a more clearer and a more pragmatic and a more friendly legal regime. So, but when they don't do that, there is also consequences. So take, for example, this case, which is Devas Mauritius Limited and others versus Republic of India. So this was a case where India, through the company Andrix, which is a private company owned by the government of India, decided to enter into an agreement, in fact, with the company Devas for developing applications employing the S-band, which is considered a scarce and valuable spectrum. Now, in 2010, citing essential security interests and citing irregularities in which the 2005 agreement was entered into, the agreement of 2005 was annulled. Now, in turn, Devas decided to take this issue to the Permanent Court of Arbitration, citing a violation of the bilateral investment treaty between India and Mauritius. So the conclusions of the court are quite interesting. While the tribunal concluded that essential security interest does justify the annulment of the contract, it did, however, make an effort to allocate the extent of decision making attributable only to essential security interest and a component of the decision making that is not attributable to essential security interest. So that part of the decision to annul, which was not attributable to essential security interest, resulted in India being held liable to pay compensation for annulling the contract, which also classified as a form of expropriation. In addition, the court also held that though India was well within its right to cite national security and not be transparent with devas as regards all the discussions in the meetings that took place behind closed doors of the Space Commission, at the very least, India ought to have notified devas well ahead in advance that there are backdoor discussions taking place, the effect of which could affect the contract with and between Antrix and devas. So that they said is the requirement under utmost good faith of principles of the bilateral investment treaty. Now, the importance of this is to also help understand that even national security, which is otherwise considered almost unassailable defense to a requirement of transparency, even that under international law was watered down to state that you don't have to discuss the nature of the discussions, but you need to at least notify the intended effect of it. Now, the lessons from this: A, understand the country in which you are investing into the space activities. So, for example, India has this concept of separation of powers. Our judiciary enjoys tremendous amount of power over practically everything. So, in the context of 2G spectrum allocation, if on the basis of public interest litigation filed by a good-spirited citizen, the court found irregularities in the way in which 2G spectrum was granted and ultimately cancelled the licenses. However, all the people who were accused of corruption in the allocation of 2G spectrum licenses also are seeing acquittals in the court. So this has also resulted in a bilateral investment treaty arbitration against India. But the lesson from this is that if you want to understand how a state will approach space, understand everything about how the state approaches non-space considerations. So the second thing that you also have to understand is that if the effort is made to align the business activity and the investment with public policy considerations, you can ensure or incentivize fair and equitable treatment beyond just the requirement of the bilateral investment. So any kind of applications or investments or products which will probably serve a public good consideration are less likely to receive the ire of the government. This also explains why the entire effort to bring in the OneWeb platform to India through the Reliance Jio was ultimately did not reach fruition because of net neutrality considerations that emerged. So therefore, it's very important that the business objectives and design actually have some sociological perspectives and they have a consideration of social equity. So last but not the least, the obvious lesson is the greater the clarity of law, the greater the investor confidence. You obviously do not want a situation where the law says seemingly gives you the impression that you will get a license for telecom operations and it is stable, only for the court to come back and take a counter review at a later time. So I come to the last aspect of a presentation, which is remote sensing and privacy. So what you see here is essentially the weed progression in a series of crops, in a weed progression in a piece of land across different months. Now, previously, this was just that. It was just pictures of land and it disclosed very minimal data. But today, that data is providing insights to us. So take the example of a real estate agent in a locality where real estate assets are driven by market factors. He can probably leverage the experience from 10 sale transactions that he has facilitated and specifically point to my house and tell me exactly what the worth of my house is and the land it is situated on. Now, if you substitute the real estate agent with a satellite, you also realize that not only do we have the layout of the land and also the building on it, but by piecing together data from other sources, you can also now estimate on the basis of a satellite image of that land what the worth of that land is, and therefore what the approximate net worth of its owner is. So there is a huge privacy implication there. Now, regulating it from a privacy point of view is obviously going to be very complicated. So the United States in the California Supreme Court took a view that if a piece of land is observed by an aircraft and it is obviously observable by an aircraft flying overhead, the landowner does not have a reasonable expectation of privacy over that portion of his land. So a person who was arrested for growing marijuana based on this aerial observation argued that there was a violation of his privacy, and that claim was ultimately negated, and the court said that there's no expectation of privacy. So if you take planes away and introduce satellites in its place, it could be argued that what is visible from space, which is not covered, is no longer protected by privacy rights under US law. Under international law, a state does not have the right to be a state does not have the right not to be observed, which means that any and every state can be observed through remote sensing. However, the state that is being observed through remote sensing has the right to receive the data on non-discriminatory terms. Under Indian law, there is a great amount of transparency around land information already. Practically every information about the land is public domain. So it could be reasonably assumed that remote sensing data or around that land will probably enjoy the same kind of regulatory benefits of transparency. The European Union and Indian regulations, however, still stipulate that data which is publicly available still has certain privacy encumbrances. There is requirement for notice to the intended data subject. There is requirement to use it only to the extent necessary to meet the processing objective. There must not be any abuse in the context of data that is publicly available. And in case tomorrow data publicly available is withdrawn from public domain, the processing activity around it must reflect the change in consent. And there is even requirement of informed consent unless specifically waived off. So these kind of perspectives can fundamentally redesign the remote sensing product itself. Take, for example, a scenario where you may want to probably look at, instead of identifying a specific worth of the rice or paddy or wheat being grown on one particular piece of land, if you do a district-wide analysis of paddy crops for that entire district, then the privacy implications reduce because the data that you're generating is anonymized. So there are significant areas of privacy concern that can be addressed right at the design of the product itself, so that tomorrow the privacy regulations do not become a headache. So to conclude, we essentially understand that space law is not really very well developed to address some of the very finer nuances of commercial space activities. So we apply precedented solutions under generic laws to unprecedented problems and queries involving space law. So technology awareness is critical. Legal problem statements like space situational awareness are now addressed through a combination of technology and legal interventions. So the ability to think wearing both hats becomes very, very important for a potential space policy or space lawyer. Thinking about the future, there are some very, very exciting topics for space lawyers to think about. Tomorrow, if we colonize Mars and we decide to terraform Mars to reflect the atmosphere of Earth, is that ethical? Is that legal? Considering that there are principles against contamination of atmosphere of outer space objects. So is Mars alive in a manner that we cannot perceive? Is life only as we see it on Earth? Or is there a definition of life that we do not understand and perceive because of our limited experiences? So the next question, there is a lot of talk about asteroid mining and mining of outer space objects, and concerns around colonization are quickly shrugged aside, citing the fact that it's purely an economic exercise. But it must be borne in mind that before India was colonized by the British, Vasco da Gama came only to explore and only to trade. So exploration led to trade, trade led to incentives, incentives led to colonization, colonization led to boundaries, boundaries in turn led to conflict. So we can reasonably assume from human history that what starts off as exploration and economic enterprise can potentially result in conflict in space. So having a conflict resolution mechanism that we are able to use to address these kind of disputes is absolutely critical to prevent a potential military culture in space itself. Last but not the least, the environmental impact on human rights. Future colonies will probably be in inhospitable atmospheres where air, water, and space will not be as available as it is in planet Earth. So take, for example, privacy rights, which stipulates or in some jurisdiction means that women and men get separate washrooms. So, or separate living spaces, in fact. Now, all that is possible by the abundance of land. Now, in a colony like Mars, where spatial abundance is probably not going to be available, how are we going to define privacy rights in a manner that best advances the human potential and best protects the human condition? So how will human rights look like for human beings that grow up on Mars may not be the same as it looks in India or in any part of the world for that matter. So we have to honestly reflect on some of the impact that space will have on the evolution of human rights, because right of clean air, which is a fundamental human right in our part of the universe, is not going to be available for a lot of Martians because clean air is not available in abundance. So I think these are some of the interesting space law considerations for future space lawyers and law students. Anybody who wants to understand the tardigrades legal issues a little better, I strongly recommend the works of my friend Daniel Porras from the UNIDR and his co-authors Christopher Johnson and Sullivan. It's a wonderful series of articles. Strongly recommend that you go through it. And for any further questions or clarifications, please feel free to reach out to me. I'm happy to address any queries. Thank you so much. Really appreciate your time, and allow me to end this presentation on a very thematically appropriate farewell note, which is live long and prosper, and may the force be with you.